Item number 1 for pronouncement of judgment.
So we have gone through the evidence record. We have discussed to the best of our ability whatever we can understand from the facts and circumstances. So it's not necessary to read the whole thing. We'll just read out the operative portion. On a final analysis of the facts and circumstances of the case of the appellant, we are of the considered view that the prosecution has not been able to make out a case for conviction of the appellant, and the impugned judgment of conviction, including the sentence thereof, is liable to be set aside and quashed, which is done so herein. The convict appellant is hereby acquitted and is directed to be henceforth set at liberty without any liability as far as this case is concerned, if not wanted in any other case. So we have based mostly, you see, Mr. Upadhyaya,
Lordship.
now that the judgment has been pronounced, we have discussed mostly on extrajudicial confession, the aspect of it. It so happened that we have passed this judgment on the day when we have extrajudicial work. Yes. You can tell it. Thank you.
Morning, sir. Sorry. May I, sir? Lordship, this is a parity-based application, bail application, of course, parity-based. I'll just take your honor through what has transpired. This is the second bail application
You see,
filed.
when you talk about parity, you have to be very careful.
I understand.
Facts, circumstances, everything has to match. It has to be ditto.
But not necessarily in parity also. I just
Otherwise,
understand. Not necessarily in parity also, Lordship. That is not the only thing I've prayed for. Lordship, first thing I would like to take your honor's attention to is that the accused has been in custody for 2 years and 2 months as on date. He's undergoing trial in a NDPS matter in Nongpo. And Lordship, this is the second bail application filed on behalf of the petitioner. The first bail application was exclusively filed on the ground of delay in trial. Your Lordship was pleased to reject that contention. After that, we went for trial. We examined a couple of witnesses, material witnesses, Caesar witnesses. Well, Lordship, their depositions have actually occasioned the filing of this particular bail. When I moved the bail application for the co-accused on the last occasion, Lordship, the critical analysis was done of the depositions. Your Honor had come to conclusion, since the Caesar witnesses have caused a dent in the prosecution matter, a ground for bail has been made out. Lordship, I'll just take you to the last annexure. Page 52.
Page
52, Lordship. This is
yes. Page 52.
page 52. Right, Your Lordship. So this is the order Your Honor had passed in the bail application of the co-accused person. I'll just read para 23. Coming back to the case in hand, what is observed is that the petitioner, having been arrested in the said case undergoing trial, the stage of the case is for recording of evidence of the prosecution witnesses, of which 3 out of 10 have been examined. The petitioner, taking note of the deposition of the 3 witnesses and finding that the statements made by these witnesses have for the moment failed to implicate the petitioner as far as possession of the alleged contraband is concerned, therefore he has approached this court with this petition seeking for grant of bail. Para 24, Lordship. This court, even if the authority cited by the PP, that is the case of Pandurang, as also the proposition found in the case of Shiv Sankar Kesri, is taken into consideration, there is no reason to indulge in critical analysis of the evidence on record, as on a bare reading of the same. The evidence of PW2 and PW3, Your Lordship, who were Caesar witnesses, have amply cleared the air that the petitioner cannot be linked to the discovery of the alleged contraband and found contraband substance found in the tin box, firstly, not from within the compound of the house of the petitioner, if at all, and secondly, certainly not from his physical possession or even conscious possession. To reinstate what has been cited at para 19 of the Muhammad Muslim case, this court is reasonably satisfied on prima facie look at the material on record that the petitioner is not guilty, that is at the time when the bail application was preferred. Lordship, we'll just stop there. And Lordship, when this, with regards to concession of bail, this particular individual on whose behalf the bail application has been preferred today, I believe is on a higher pedestal, and I say why, Your Lordship. I'll take you to the FIR, which is at page, 26.
Yes.
All right. 26 is the FIR.
Please.
Now, if you just read the first para, what we will come to note is basically the accused on whose behalf the petition is being preferred basically came on that particular day, on the fateful day, dropped the consignment and left. I'll just read the first para. With reference to the subject cited above, I am to inform you that on the 30th of June 2023, at around 8 p.m., received a credible information from a reliable source that 3 persons, namely Ronald, Dong, and alias Sean and Nava Singh, were assembling at a farmhouse of Ronald Kenya at Lumkeni village to transact a big consignment of drugs. On receiving the information, a Naka checking was set up at Umsning Junction bypass on NH06 along with the available staff of Umsning police station. At the Naka, one black Alto was intercepted at the Naka with 2 occupants. Upon questioning them, they stated the names are Ronald and Daniel CM. They were unwilling to reveal the location of the drugs. So, Lordship, these two individuals have already been granted bail. We go to the next paragraph. During interrogation, they stated that the third person was moving towards Guwahati, after which another Naka was set up near Barnihat and he was detained later that night at the Naka. So he was brought in from some other location, Your Lordship. He was not along with the accused persons who have already been granted bail. On further interrogation, with each separately, each of them confirmed the drug consignment location somewhere inside Ronald's uncle's farmhouse at Lumkendi village, Umran. However, since it was late and it's already 1 a.m., the accused persons along with the vehicle were detained. The matter was intimated to the Superintendent of Police. Following this, on the 1st of July 2023, K9 Dog Squad is requisitioned from the CIT, and after receiving authorization, etc., for conducting search at the premises, in the presence of independent witnesses, search was conducted at the aforementioned farmhouse. The sniffer dogs from the K9 unit identified an iron box suspected to be contraband. On opening it, 70 soap boxes were recovered. Not sure we'll stop there. So basically, the allegation is that he had dropped the consignment and left. We have examined both the Caesar witnesses on the last occasion. Analysis was also done by the Honorable Court. The Honor came to the conclusion that I've just read out the relevant parts of the order, that they have failed to implicate the accused persons on account of them having had said that the contraband was basically not seized from within the premise but was brought from someplace else, and various other things. I'll also take you to the list of witnesses just for the court's satisfaction, which is at page 35. So page 35 is a page from the charge sheet.
Yes.
Page 35 is a page from the charge sheet. My endeavor, Lordship, is basically to show that the material witnesses have been examined who would have also implicated this present accused person as well. We'll check the first person who's been mentioned in this Caesar list. He's Head Constable KB Marak. He's the complainant. He's been examined, Your Lordship. PW2 Dorsai has been examined. PW3 Petrus has also been examined. Now these two individuals were the Caesar witnesses, PW2 and 3, Your Lordship. And if you see PW4 and Lordship and PW5, they are individuals from the same vicinity, from the same village. If you see the addresses, Your Lordship, they are also people who were in and around the farmhouse, from where it was alleged that contraband was recovered. Now, Your Lordship, what I endeavor to put before this court is that the Caesar witnesses who have been examined, they have basically put before the court that they do not know where it came from. It came from outside. The police brought it and kept it. Now, since that has been established by the Caesar witnesses, and on account of that, a person has been granted bail. The person who had allegedly gone and kept it there, I believe some kind of parity would also apply to that particular person, individual, or to that individual. Hence, on these accords, Lordship, I seek bail. Because again, like I say, the Caesar witness couldn't establish the Caesar. The allegation as per the FIR and the charge sheet also is that this person had dropped the consignment there. But the witnesses said no. We did not see from where the consignment came. The police brought it from outside. I hope Your Honor recalls that case, Your Lordship.
You expect if somebody has dropped some consignment somewhere, you expect there will be people waiting?
No, absolutely not. Absolutely not.
Somebody witnessing such a scene.
No, of course not. But Lordship, what I mean to endeavor, perhaps also
We
coming
just have to look at the accompanying evidence.
Circumstances. Yes.
Circumstances, whether that
Lordship, then again we must look at the list of witnesses. What I mean to say is the first witness has been examined, who's Mr. Mara. 2 and 3 have been examined, who are the Caesar witnesses. PW4, Julius Thongni, and 5 are basically individuals from the same village, Your Lordship. They're not Caesar witnesses, but their 161s are basically on the ground only, that on one particular day the police came and made a Caesar. Page 35.
Have you enclosed any materials on
I've enclosed the charge sheet, Your Lordship.
the evidence against this petitioner?
No, there's nothing, Your Lordship. The charge sheet is there. The charge sheet. Nothing. It only says that on account of them having had said we have another third person accomplice, police went to Barnihad and picked him up and brought him back to the farmhouse. That is all. I can read the charge sheet in its entirety, Your Lordship. It is at page 36.
This is the charge sheet?
That's the charge sheet, Your Lordship.
36 to 42?
36 to the rest of the pages are charge sheets, Your Lordship.
Only
36 to 42. The findings are all here.
Only 3-4 page of charge sheet.
That is about.
Oh, no, Lordship. It starts from page 27. 27 to 42. Oh, sorry. 29 to...
Yes, Mr. Guru, what do you say?
42, Your Lordship.
My Lord, firstly, Lordship had rightly, my Lord, observed that when it comes to parity, my Lord, everything has to be same, my Lord. Here, as per the FIR, the involvement of the petitioner and the one Donald who was granted bail, my lord, is completely Ronald, are completely different, my lord. One is supplier, my lord. The other is purchaser. So therefore, my lord, supplier and purchaser, my lord, they cannot come with a petition on parity, my lord, because their role is completely different. That apart, my lord, a supplier should be kept in a higher pedestal, my lord.
Mr. Sorry to interrupt you, Mr. Guru. If you say supplier, that's what I was inquiring about from the charge sheet or evidence. Where is the indication or proof that he is the supplier?
My lord.
Or even if not proof, we may not go into the final analysis, but some insinuation that he is the supplier.
Yes, it is there, my lord. That apart, my lord, in fact, my lord, there are other two persons also who had been assisting the present petitioner who are not reflected here, my lord. That might even come subsequently. Kindly come to the FIR, my lord.
Yes.
Page 26.
Wait. Just a second, my lord. My lord, we'll come to page 36, my lord.
36.
Charge sheet.
Yes.
Kindly come to page 40. I'm sorry, my lord.
40.
Page?
Page 40.
40.
I'll read the second paragraph, my lord. Further, during the course of investigations of the case, it is well established that Sri Tokcham Nava Singh, the present petitioner, my lord, son of Sri Tokcham Lal Singh of Kongmong, Imphal West, Manipur, along with one Thongboy and one unknown person brought the consignment. So there are two other persons involved here, my lord. Apart from the co-accused, my lord, there are two more who had been assisting the present petitioner, my lord.
That's why I see, Mr. Guru. This has been stated in the the findings of the IO. But where is the 161 connected with this? Somebody must have said that he is the supplier. He has connection with this so and so person.
If I may, Lordship, if Your Honor doesn't mind, the only person who has actually brought his involvement up are the accused persons.
My lord,
it's clear from the FIR. I'm sorry.
Doesn't matter. From somewhere there must be something.
No, there's nothing.
My lord, 161 statements, nothing is enclosed here, my lord. I'm submitting from what is enclosed here, my lord.
That will be
exactly, my lord.
Lordship, I'll take. I can endeavor to, if Your Honor allows me, as to whether there is actually evidence on record or not. First thing, Lordship, I'd raised.
You have the set of complete set.
161's nothing is mentioned about.
I'm not talking about the charge sheet as a whole.
This is the entire charge sheet, Lordship. I have it.
No, there has to be 161. Otherwise, there's no question of charge sheet being filed.
Lordship, there is, but what I mean to endeavor again, I'll take
you. You do one thing, Mr. I think I'll have to produce the CD.
Exactly. That about, my lord, in this case, there is a flight risk, my lord. It cannot be, my lord.
That is, of course, that will all those will be taken into account. But it's for the satisfaction of this court.
Exactly.
You see, this observation has to be based on some evidence, some statement.
Exactly.
As to how the IO has come to this, conclusion.
My lord.
So, but nothing is there.
Nothing is there.
Lordship,
we'll take it up on 4th.
On the 4th, which would be a Thursday. Lordship, if Your Honor is alright to accommodate, on the 4th, Lordship, I have to go out of station. If Your Honor can accommodate me on any. If 3rd, Your Lordship, if it's alright, I kindly request. 4th and 5th, I'll be traveling.
3rd, because you see, under day we have, 2 to 3. In fact, I have 2 dB.
Oh.
Single. So it may not be, time would be a problem. That's why I'm saying 4th or 5th, or finally Monday, 8th.
The coming few days would be difficult for you, Honor. Too many DBs, like
Then
Your Honor
So
said.
on 8th, we'll have it on 8th.
Lordship, then we can have it on, just check.
Whatever you suggest a date.
Just a second. So I'm sorry, so because it gets 5th is okay, no? So 5th.
5th.
I'll make an endeavor to be here. 5th. I'll go after.
In the meantime, the complete charge sheet may be provided.
You have to produce.
But this is the
I
entire
has to
charge sheet.
produce the
The rest are
charge.
Caesarless and
No,
all
the
that.
161 statements.
160.
Mr. Guru, you have to produce the
Lord.
charge sheet. Yeah,
Because-
because
because
you see, you have to produce the charge sheet. You have to point out to the court the relevant portion implicating the petitioner. So, it's not that the petitioner will produce the charge sheet. It's not incumbent upon him.
My lord.
Lordship, if I may just, I know we have dealt with the matter, date has already been fixed, but if I may just to assist the court, out of 10 witnesses examined, Your Lordship, 10 witnesses on record who are yet to be, who are to be examined, 3 have been examined who are Caesar witnesses. The 2 other independent witnesses are from the same village. So they are confined to the fact of recovery being made or not made from the house. The rest of the witnesses are all official.
Whatever the case may
And
be.
that part, even 161 of the.
That is not the domain of this court, because that would be the I would say the duty of the trial court to look into.
And there's no CDR also connecting these individuals. Anyway, we'll take it up on that.
Heard Mr. Siada, learned counsel for the petitioner, who has submitted that this petition has been filed under section 483 of the BNSS. We pray for grant of bail to the petitioner herein, who is an accused
1, 2, 3, 4.
standing trial
161
in connection with
accused.
firstly Umsning PS case number 21-7 2023 under section 21C and 29 of the NDPS Act, and which case on being charge sheeted and taken cognizance of by the learned special judge
Oh, not a holiday.
NDPS Dubai district is registered as
Registered as PS case, Lordship. PS case is, I'm so sorry. The PS case is, Your Lordship, 21/7/2023. Umsning PS case number.
no, I'm talking the case before the trial
Post in the code it's registered as 23 of 23. NDPS 23 of 23.
case number 23 of 2023. Mr. R. Guru, the GA has accepted notice on behalf of the respondents herein. However, in course of hearing, it is seen that it is noticed that the charge sheet, the complete set of charge sheet, has not been annexed with the petition, which would assist the court in dealing with this matter by referring to relevant portions of the findings and observation made by the IO, which has been duly noted down in a set case diary. Accordingly, on prayer made by the learned GA, the copy of the charge sheet is directed to be the case diary, including the charge sheet, is directed to be filed, to be produced before this court on the next date fixed. As prayed for by the parties, this is matter for further hearing on 5th.
5th. Should I make an endeavor to file the 161s just to help?
That will be included.
I'll be filing the complete charge sheet.
Then you file the complete set, and then, with the usual
My lord.
page mark, flag mark, whatever.
Highly advised, Lordship. Good day, Lordship.
Yes, sir. Intimating a reference to the cited above.
Thank you.
Okay, thank you. Okay. Cited above. And as per the order of the Honorable High Court of Meghalaya, you are hereby directed to